Office of the Court Administrator vs. Judge Reyes, AMNO. RTJ 20-2579. Facts. In 2018, a laptop was assigned to Judge Ordinarily C. Reyes as acting judge of Regional Trial Court Branch 39, Roxas City. In 2019, the laptop was turned over to Judge Josephine Carranzo upon her appointment as judge of Regional Trial Court 39. Judge Carranzo, however, submitted the laptop to the Supreme Court's Management Information Systems Office for repair. In 2020, the Management Information Systems Office, while examining the laptop, uncovered several exchanges of messages between Judge Reyes and certain lawyers and with one politician, Mayor Joselito Malabanan. Specifically, Judge Reyes, 1. Borrowed money and asked for pabayan or pocket money from attorney Moxino whenever Judge Reyes attended seminars and trainings. 2. Asked attorney Misanke to be his dummy. In a transaction involving a 900 square meter lot that Judge Reyes owns. And 3. Received money, a car, and guns from private practitioners in exchange for favorable action. The Management Information Systems Office endorsed the matter to the Office of the Court Administrator and after conducting an investigation recommended the dismissal from the service of Judge Reyes. In his defense, Judge Reyes argued that the evidence against him should not be admitted for being a fruit of the poisonous tree. Issue: whether or not Judge Reyes' argument is valid. Held: no. The right to privacy is a fundamental right against the state's intrusion into personal matters. To implement the right, our Constitution guarantees every person the right to due process, to be secure against unreasonable searches and seizures, and to the privacy of their communication and correspondence. However, Judge Reyes cannot invoke the same in this case. The doctrine of the fruit of the poisonous tree is an exclusionary rule which basically states that an evidence illegally obtained shall not be used in any proceeding. However, the rule admits of certain exceptions which are 1. The independent source exception and 2. The inevitable discovery exception. In this case, the Supreme Court used the inevitable discovery exception as it appears that the Philippine National Police was already investigating the matter as early as April 2019 by reason of a CIDG memorandum. As such, even without the judicial audit conducted by the Office of the Court Administrator, the Supreme Court would have inevitably found out about Judge Reyes's corrupt acts since the Philippine National Police would have informed the Supreme Court anyway of its findings against Judge Reyes. Furthermore, Judge Reyes has no reasonable expectation of privacy in using a government-issued laptop. The Supreme Court's policy is clear that there should be no expectation of privacy in court-issued computers. To quote Section 9, Paragraph 3. No privacy in electronic communications. Users must never consider electronic communications to be private or secure. Electronic mail and other electronic communications may be stored indefinitely on any number of computers other than the recipient's. The Supreme Court reserves the right to monitor and/or log all network-based activities. The user is responsible for surrendering all passwords, files, and/or other required resources if requested to do so in the presence of his/her office head or persons properly authorized by the court. Computer Guidelines and Policies, AM number 05-3-08, SC, March 15, 2005. With the foregoing, Judge Reyes cannot invoke that there has been an invasion of his privacy. In a per curiam decision, the court en banc found Judge Ordinarily C. Reyes, presiding judge of Branch 43, Regional Trial Court of Roxas, Oriental Mindoro, guilty of gross misconduct and ordered his dismissal from service. The court also ordered the forfeiture of his retirement and other benefits, except accrued leave credits, and his perpetual disqualification from reemployment in any branch or agency of the government, including government-owned or controlled corporations.